What starts as a routine bond hearing quickly turns into a heated debate over one critical question. Should a repeat drunk driving defendant remain free while awaiting trial? Prosecutors believe the evidence points to a dangerous pattern that puts the public at risk. The defense argues there's an important legal gray area, claiming the positive drug test may have come from substances used before the defendant was even released on bond. But here's the twist. The judge isn't just focused on one drug test. He's looking at years of prior OWI convictions, another pending case, and whether the court can afford to take another chance. As this hearing unfolds, watch closely because every argument shifts the focus from technical legal rules to one much bigger issue: public safety versus the presumption of innocence. By the end of this hearing, one decision changes everything.
Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart. What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report in receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check X jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those.
What?
I mean, cocaine could stay in a system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County. Then I think that his bond in these cases is inappropriately set.
Notice how the discussion is no longer centered only on whether the positive drug test counts as a bond violation. The judge has already begun shifting toward a completely different legal analysis. Courts don't simply ask whether someone technically violated bond. They also consider whether the original bond conditions were appropriate in the first place. That's a major distinction. Even if the defense succeeds in arguing that the cocaine remained in the defendant's system from before release, the judge can still conclude that repeated OWI arrests and ongoing substance abuse create an unacceptable risk to the community. Here's a question for you. Should judges focus more on technical legal timelines, or should protecting public safety always come first?
And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's, again, my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle. Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
Yeah, may I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his VAC was incredibly high. And I'm going to double check that before I give that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is.
This may be the turning point of the entire hearing. The prosecutor isn't relying on just one failed drug screen anymore. Instead, they're building what lawyers call a pattern of conduct argument. Multiple prior OWI convictions, another pending criminal case, and allegations of extremely high blood alcohol levels all combine into one narrative. This isn't being presented as a single mistake. It is being portrayed as repeated dangerous behavior. Meanwhile, the defense continues emphasizing that there's no evidence the defendant was actually driving while impaired after release. It's a fascinating clash between two legal philosophies: punishment based on proven conduct versus preventative measures designed to protect the public before another tragedy can happen.
People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think It would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash as surety.
And there it is, the decision everyone was waiting for. Instead of allowing the defendant to remain free on a personal recognizance bond, the judge raises the bond to Ursarwar Lincash, or surety. That's a significant change because it dramatically increases the conditions required for release. Notice that the judge doesn't spend much time debating the exact timing of the drug use anymore. His ruling reflects a broader concern that the overall history, combined with multiple pending OWI cases, presents too much risk. Whether you agree or disagree with that reasoning, it's a powerful example of how judges often evaluate the totality of the circumstances rather than one isolated piece of evidence. No.
So you're waiving your right to preliminary examination in these cases? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you will not have that hearing on either one of these matters and that this will proceed to circuit court for further resolution? Yes, sir. People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might have been PRs, maybe $25,000 PRs, but
I have on each of these that they're PR.
Oh, I apologize, Your Honor. My mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on the single count in each case.
We'll stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Simon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters.
This hearing ultimately became about much more than a single positive drug test. While the defense argued there wasn't conclusive proof that drugs were used after the defendant was released on bond, the prosecution successfully shifted the court's attention toward the defendant's overall record, multiple prior OWI convictions, another pending case, and an ongoing history of substance abuse. The judge ultimately determined those factors justified increasing the bond from a personal recognizance release to Ursarwar Lincash or surety before sending both felony OWQI cases to circuit court for the next phase of proceedings. It's a reminder that bond hearings aren't about deciding guilt or innocence. They're about balancing defendant's rights with the court's responsibility to protect the community while the criminal case moves forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom breakdowns, legal analysis, and the most compelling real courtroom moments from across the country.